morning, everyone. My name is Jack, and I'm the Director of Consumer Protection at the Competition and Consumer Commission of Singapore, or in short, CCCS. This is CCCS' first virtual outreach event since the issuance of the price transparency guidelines. We thank you for taking the time to join us. We would also like to thank the Singapore Chinese Chamber of Commerce and Industry for organizing this event. Today, we will be sharing with you briefly on the Consumer Protection Fair Trading Act and the key points of the pricing practices in the guidelines. Transparent and accurate prices allow consumers to make informed purchasing decisions, which are essential in a well-functioning market. The guidelines set out how CCCS will interpret and give effect to the Consumer Protection Fair Trading Act in relation to the display and advertisements of prices. The guidelines will come into effect on 1st November 2020 and will apply to all suppliers, whether operating online or in physical stores. Please save your questions till the end of the presentation, where we will open the floor for Q&A. Thank you.
Morning, everyone, again. I'll just very quickly share the slides. It's actually very heartening to know that a lot of you are very keen to learn more about the price transparency guidelines, which has just been published. But we thought before we jump straight into this, it would be good for us to maybe share with you, to give you an overview of the consumer protection regime in Singapore, as well as some of the things that we do at CCCS, as well as the Consumer Protection Fair Trading Act, which is the piece of legislation that the guidelines are based on. So I'll move on to the presentation pop-up. So in front of you, you will see, it's a very quick overview of the consumer protection regime in Singapore. Other than CCCS, we also work very closely with CASE. I think most of you are quite familiar with them, as well as with the Singapore Tourism Board, STB. So what we do is that we will reach out to both consumers and suppliers in our upstream preventive efforts in terms of educating, outreaching to them. CASE will mainly focus on the consumers. I guess you can tell from their name. Singapore Tourism Board will be more in terms of the tourists, outreaching to them. For CCCS, we have been focusing more on suppliers. But we realized that in the course of all these outreach activities, it's been very key that we all work together. So that has been usually how we have been doing that for the past years. And we believe we'll continue to do so as well. So if you're looking at redress matters from consumers, say they have certain complaints that they want to feedback, or they want to get some compensation for certain disputes that they have with their suppliers, then that's where CASE and STB will come into the picture. By law, CCCS, we don't have the mandate to look into redress matters. So CASE and STB takes the lead in this. CASE, of course, focuses on the local consumers, whereas for STB, they will help the tourists. And so CASE will help the consumers in terms of negotiation with suppliers or mediation. As well as if there's really any unfair practice that the suppliers have engaged in, then they will look at inviting them into signing a voluntary compliance agreement. So it's an agreement that the suppliers make with CASE or SDB in this case, where they will undertake not to engage in the unfair practice again. So of course there would be cases where the suppliers don't even want to sign the agreement in the first place, right? Don't even want to sign the VCA, or they signed it and subsequently they again infringe it by engaging in more unfair practices. Then that's when CASE and STB, after their evaluation, they may refer some of these suppliers to CCCS for our investigation. And through our investigation, if we realize that there's really unfair practices that these suppliers have engaged in, and it's persistent, right? It's not just a one-off or 1 or 2 times, but it's really persistently they have been engaging in these unfair practices, then we will consider taking up an injunction order with the courts so as to stop the suppliers from engaging in any further unfair practices. So in the gist, this is the consumer protection regime in Singapore, and we just want to highlight that in terms of consumer and supplier disputes, case and STB are the first points of contact, what we call. They are the sort of like the first port of call that consumers will go to. And it's not just in terms of redress or compensation, but also if there are any unfair practices that consumers come across, they should also reach out to case and STB to provide such feedback so that they can help to look into the matter, so that it's an escalating set of measures that we are engaging it in. And it's only the very persistently errant retailers that we will take enforcement action against in terms of injunction, as I mentioned. So moving on, maybe I can talk a little bit more about the Competition and Consumer Commission of Singapore, or CCCS. We are a state board under the Ministry of Trade and Industry, and we are responsible for administering and enforcing the Competition Act as well as the Consumer Protection Fair Trading Act. So for the purposes of today's webinar, we'll be focusing more on Consumer Protection Fair Trading Act, or in short, CPFTA. So we are empowered to investigate, as I mentioned just now, for persistently errant retailers, and also to apply for declaration or injunction if we find out through our investigation that suppliers have been persistent in their unfair practices, and to enforce compliance with the injunction orders after these orders have been granted by the court. So I'll move on to give you a bit of idea of the Consumer Protection Fair Trading Act. So the CPFTA, under that, a supplier should not make any false or misleading claims on the provision of any goods or services. So by this, we are saying that perhaps if you're looking at false claim, it's something that is not even true in the first place. It's not even there in the first place, and you are making those claims. Misleading claims could be it's maybe there, but you are omitting certain things. You're not telling the consumers, or you are saying certain things that may mislead the consumers to think otherwise. So that could be an example of a misleading claim. I think when I go through the presentation, you'll see more of that, and hopefully there's clarity in that. So in the Act, so in gist, it's that you should not make any false or misleading claims on goods or services. And there's also 27 specific unfair practices in the second schedule to the CPFTA. So if you Google the Act online, you can see in the second schedule, which is towards the end of the piece of legislation, that there are 27 specific practices where it's not meant to be exhaustive in that sense, but it's really meant to provide certain clarity when you look at misleading or false claims, and when we talk about unfair practices, then what are they? What are some of the examples that suppliers could refer in the course of doing business? So maybe after this webinar, if you're interested, you can take a look at that. So we have pulled out some examples of the unfair practices in the second schedule, which we think are very relevant to prices and pricing practices in this for the guidelines. So if you look at unfair practice number 7, it talks about representing that a price benefit or advantage exists, respecting goods or services, if the price or price benefit or advantage does not exist in the first place. So an example that is given for this is that it could be that you're selling a set of headphones for $25. So you said that, and you stated out that in terms of your competitor's price is put as $50. So there's a price advantage of $25. You're selling the headphones at $25 cheaper. But really, if consumers do a comparison of the prices, they will realize that the competitor is actually really selling theirs at $25 also. So there's no real advantage or benefit that you're talking about. So that in itself is an unfair practice. So moving on, if we look at unfair practice number 8, that is charging a price for goods or services that is substantially higher than the price that is provided to the consumer, except where the consumer has expressly agreed to the higher price in advance, right? So, so an example that we have for this is that if you are a hoteler, for instance, so you charge, you advertise your room at $200 per night, for instance, but at the end of it, when the consumer is ready to pay for his or her stay throughout, maybe 3 days, for instance, suddenly there's an additional charge, additional mandatory cleaning charge of say $100. So in the end, the consumer needs to pay 200 times 3, 600 plus that $100 for cleaning. By this, of course, we don't mean perhaps the consumer had made a mess of the room. So, additional charges would have to be incurred because you have to, get more people to come in to clean the room. It's not that. It's more of charges that you already know would have to be incurred. You will be charging this to every single customer of yours. It is one of the charges, yes, that would be added to the total in any case. So right up front, you would have already known that this is something that would have been charged. So you should put it up front, right? You should have advertised it as $300 per night, for instance, instead of putting it down to $200 and misleading consumers to think that, hey, this is a room that is cheaper, and then charging them higher at the end when they have no choice but to pay for that. Yeah, so that's an example of unfair practice 8. If we move on to look at unfair practice 18, that's when we represent that goods or services are available at a discounted price for a certain period of time. If the supplier knows or ought to know that the goods or services will continue to be so available for a substantially longer period. Okay, so by this we mean examples where, say, closing down sale, right? The example that we have, 50% closing down sale. So usually people, consumers will think that, oh, it's a closing down sale, 50%. That's great. I want to buy the goods now because it's going to close down. I should buy it soon, right? So that I can get that 50% discount. But if your closing down sale then goes on for a year, for instance, then it's really not a discount in the first place. It's an unfair practice. It's a claim that is potentially misleading or even false to consumers. So this is something that we will have to, that as suppliers, you need to take note of. We are not prescribing that, if you are looking at a sale or issuing a discount, then there's a certain, you can only look at it for 1 month or 2 months or 3 months. We're not doing that. We're not prescribing that in the guidelines. But we just want to set broad guidance that this is not something that you should do. And in terms of how acceptable it is or how long it will be, then it will be something that is, we think, by market forces or relevant to your industry. But yeah, we will have to take note, because usually if you look at a discount that goes on for a year, that is really not something that is quite usual or should happen in the first place. Right, so I think to sum up the CPFTA, the objective is really to protect consumers against unfair trade practices, to ensure that businesses will be able to compete fairly, and to hold, as I mentioned earlier, persistently errant businesses accountable if they engage in any unfair practices. So they are, because when they do that, they may, get more. They may get more sales as a result. But then suppliers who are keen, who have dutifully towed the line, they have been competing fairly, they have not engaged in unfair practice, will then they will be compromised. So we want to make sure that in the market, in the whole industry, throughout all businesses, we are really looking at businesses which are fair. So I will move on to talk about the guidelines on price transparency. So maybe some of you will ask, why would we want to focus on prices and pricing practices as the first set of guidelines for CCCS? I'm not sure if many of you are aware, but the Consumer Protection Division that Jack and I and a lot of my other colleagues are from, we used to be from Spring, Singapore, and we moved over to CCCS about two years back. And so that we wanted to have greater synergy between the competition side as well as consumer protection. That's also what a lot of other jurisdictions are doing. So this is the first set of guidelines that the Consumer Protection Division have developed. So why do we think it's important? It's because really we see that transparent prices will allow consumers to make informed purchasing decisions. And they are also very essential to a well-functioning market, right? If there are no transparent prices, everyone is just trying to subsume, hide certain prices, then no one will be able to make informed purchasing decisions. And there will be a lot of complaints, there will be a lot of disputes and unhappiness, because eventually if consumers have to pay for something that is higher than what they thought they would be paying, usually it wouldn't go down well with them. That's why we think it's important to at least provide some guidance in this area. So consumers as well, suppliers as well as consumers alike will be able to see how transparent prices and listing prices clearly and prominently will be important for all. And so yeah, in the same light, because if they display, if suppliers display or advertise prices, this will have a very significant impact on consumers' behavior and decisions. Like I mentioned, sometimes consumers may buy something because of a low price that is advertised, but eventually if they realize that, hey, they have to pay much more, then there could be a lot of dispute and unhappiness that results. Yeah, and hence the last point about suppliers could also, in a way, some of them who engage in unfair practices could potentially misuse some of the advertisement of prices or price displays and pricing strategies to which could lead to consumers' detriment. So the key principle of the guidelines really is that suppliers should ensure that prices and their accompanying conditions or any terms and conditions, they are accurate, they're communicated clearly and prominently so that consumers can make informed choices. This is the running theme, this is the main principle that is key throughout the whole guidelines, whether you're looking at whichever pricing practice that the guidelines talk about, which we're going to talk about soon. But this is really the key principle which runs throughout, and the most important thing that suppliers should take note of. So we highlighted 10 points that we think would be helpful to suppliers. Of course, if we have time, do take a read through the whole set of guidelines, but we thought if you want some quick pointers, then this could be hopefully helpful to you. So the guidelines indicate the manner in which CCCS will interpret the CPFTA in relation to the display or advertisement of prices and pricing practices. So by this, we mean that because, as I mentioned, the CPFTA is already in effect, right? The law is already in effect. What we are trying to do with the guidelines is that we're not trying to introduce something that is new. We are taking reference from the guidelines, as you've seen just now when I pointed out certain unfair practices in the second schedule. We're pulling them out, we're interpreting them to say, okay, if you're looking at this certain unfair practice, then what are some of the things that you should do, you should avoid? What are some of the things that would be okay, for instance, to look at? So that bridges on to point 2, where the guidelines indicate some of the factors or circumstances that CCCS may consider, right, when we're assessing whether the displayed prices and pricing practices are potentially misleading. Yeah, it could be certain factors or circumstances that the suppliers are undergoing at that point in time. So these are all things that we will take note of when we are assessing whether there's any potential unfair practices. And the guidelines, as I mentioned, include actions that suppliers should take. And also, you can see in the guidelines that there are certain what we call CCCS's positions, where it's by law, according to the CPFTA, these are actions that suppliers should not engage in. So we have listed them out. There's also a section on good practices where it's not mandated by law, but yet it's good for suppliers to do that so that it's clear for consumers. All these are listed out to them so that you can hopefully be able to reduce disputes with consumers. So yeah, that's how the guidelines have been structured. Another key point that we want to highlight is that the guidelines will apply to all suppliers, whether online or in physical stores, and we're not looking at specifically for, say, the travel industry or the online e-commerce industry, or certain retailers in physical stores. This set of guidelines is really open to all, of course, but it's also applicable to all, and all suppliers should refer it when you are pricing your products, when you're pricing your services, and when you engage in any pricing practices. Of course, certain areas and aspects of or sections of the guidelines may be more relevant to certain industries, certain markets, or certain, or you know, if you're an online store, then some parts may be more relevant to you versus if you're a physical store, for instance, or vice versa. But what we're saying is that most, if not all, of the items should apply, and yeah, it's just whether particular specific liners apply to you for a particular practice that you're engaging in, for instance. And just to highlight that in section A1 of the CPFTA, if there's any dispute between a supplier and a consumer, by law, the supplier bears the burden of proving that he or she has complied with the CPFTA. By this, we mean that the burden is on the supplier to prove that he or she has not committed an unfair practice if you're in a court proceeding with a consumer. So it's not on the, by this we are saying that by law, it's not the consumer who needs to adduce certain evidence. It's the burden is on the supplier to do so. So when I explain later with regard to some of the pricing practices, maybe then it's hopefully a bit clearer in terms of how you can manage that burden. Moving on, so the guidelines are not a substitute for the CPFTA or its regulations. I think it's similar to point 1 that I've mentioned just now. In terms of the CPFTA, it's already in effect. So, and the guidelines are not meant to replace the CPFTA, but it's really meant to show greater clarity on what the CPFTA is talking about for certain unfair practices that are relevant to prices or pricing practices, right? And the guidelines do not absolve suppliers from obligations under other acts or any other regulations from other sectoral regulators. So yes, if there are other, mainly we would say the guidelines are in sync with other pieces of legislations which are administered by the other sectoral regulators, but it's not meant to take over them. It also wouldn't absolve, like we mentioned, suppliers from obligations, but it's meant to hopefully complement them. And if there are other sectoral regulator act relevant to a particular industry, for instance, say like banking, then maybe the Banking Act or certain legislation under MAS may be a bit more relevant. So yeah, it's not meant to say that once I align to this set of guidelines, then I don't need to look at others by other sectoral regulators. That's not the aim of these guidelines. And of course, the examples and the guidelines that we have tried to provide is not exhaustive. It's really meant for illustration purposes. And there's no limit that's set on the investigation and enforcement actions on CCCS. And again, I think I did talk about that previously, that each case or each potential violation, the facts and circumstances of each case will be considered. So it's not a one-size-fits-all. It's meant to be more of in terms of broad guidance, but in terms of every specific case, the facts and circumstances will be considered. Okay, so these are the 4 pricing practices that has been expounded on in the guidelines. So first up, we have drip pricing. So drip pricing is defined as the practice of advertising a product or service at a lower headline price. By this, we mean the total price that is being displayed or advertised upfront, whether it's online advertisements or in newspapers, for instance. Then the final price a consumer would pay, right? So the increase in total price is usually the result of disclosing additional, whether it's a mandatory or optional fees or charges along the transaction process. So a common method that we observe how suppliers do this is through the use of pre-check boxes. So our position is that suppliers should ensure that any unavoidable or mandatory fees So this could be in terms of taxes, for instance, surcharges or service fees are included in the total headline price. So you don't add it in only at the end, where the consumers have gone through all the processes of choosing the various items, the various services, goods, and then at the end you suddenly add on a tax, for instance. So if you know that this tax will be added on, it's a mandatory tax or it's unavoidable, then it should be included in the headline price upfront, right at the start. And if you use any pre-tick boxes, then the suppliers, you must provide disclosures of the goods or services. If there are any key terms and conditions that accompany the goods or services that are pre-ticked, for instance, you have to list them in a clear and prominent manner so that consumers are aware that in allowing in not removing this pre-tick, they will be incurring this cost, for instance, for a particular good, or there will be certain terms and conditions that accompany this particular good that they would have to take note of. So yeah, this would have to be clear and prominent to consumers. And another key point to note is that the cost of pre-tick optional add-ons, even if it's optional, is as long as you pre-take it, then this should be included in the headline price. As I mentioned, the headline price we're talking about is the total price, right? That is put up front. So if you're looking at even if it's an optional cost, right? That that will not be may not be imposed on consumers, but because you've pre-checked it, consumers could potentially miss it, right, in the transaction process. So they could probably leave that in, and eventually they will end up having to pay for this because they overlooked it or they forgot to remove that pre-tick box. So because of that, we're saying that even if it's optional, as long as you pre-take it, you will have to include the price of that particular item in the headline price, in the total price. So if suppliers think that that would unnecessarily jack up their price, jack up their total headline price and make them less competitive, then our recommendation really, if you look at the blue box on the right-hand side of the slide, then our recommendation really is to adopt an opt-in or opt-neutral approach instead of the pre-tick approach, where through this, so you're having selections there where consumers, it's not pre-tick, right? So consumers would have to make an express decision. They will have to decide whether they will want to choose A or B, they want to choose yes or no. And say for the opt-neutral option, it's even important before they move on to the next slide, so or the next page. So it's important that we think that it will be helpful for consumers because then it will also remove any possibility of disputes because consumers would have made that informed decision, right? And of course, disclosures would have to be clear and prominent. I've mentioned that. And the need to provide a final itemized kind of price listing. So for this, we're saying that before the consumer make payment, it's good to list down exactly and itemize that all the items that consumers would have to be paying, right, in this particular transaction. So it could be mandatory items, it could be optional items, but whatever that the consumer has opted in or have missed removing, for instance, so that the consumer can have a clear idea that the total cost that he or she is paying is because of this particular items. And at this stage, it would be helpful if if consumers want to remove any items, it would be helpful if they don't need to be brought back right from this, to the start to redo the whole process again. But instead, it will be good if they can actually remove certain items if they want at this point in time, or add certain items, of course, at this point in time without having to go back. And yet, that the final total price would be something that is that they have thought through and they have agreed upon. Okay, so that is on price drip pricing. I'll move on to price comparison. Suppliers sometimes makes price comparisons with their competitors to indicate a competitive price or price advantage. So sometimes you will see claims made like ours is the best price in Singapore, ours is the lowest price, right? So our position is that suppliers should ensure that any representations or price comparisons that suppliers make with other suppliers' prices, or if you use any terms like say cost price and all that, you should ensure that they are not false or misleading. And in order to reflect the comparison of prices truthfully, suppliers should conduct their own research, right? So by this, we mean that you should compare prices with your other competitors, and it should be done periodically. It shouldn't be done just one-off, and then you say that, okay, I have a lower price. There should be some deeper form of research that is done in terms of the comparison. And one thing to note is that the product or the service that you're comparing, especially for products, I guess, it must be accepted to be similar or equivalent by consumers or by trade norms. So by this, we mean that, for instance, if you are selling laptops, for instance, right, and you compare and you say that, oh, I'm selling at a lower price this particular laptop of this particular brand as compared to my competitor. But actually, if you compare in terms of the specs, it's a higher model that your competitor is selling. So of course, the price will be higher. So you must compare prices of products which are similar. At least even if it's not by trade norms, at least the consumers would view them to be similar or equivalent. And just one point to note that even if you agree to provide refunds, that does not absolve you from having to conduct research and to ensure that any claims or representations that you make of when you compare prices with your competitors, they have to be accurate, they need to be genuine, they must not be false or misleading. Right, so in terms of good practices, we think that it's important to keep records, like I mentioned, in terms of price comparisons with your competitors. And you also need to check these prices periodically, right? So it's not just a one-off that you check and then that's it, but you should go back to ensure that if you're making any comparison, say you're the lowest price, then you should compare it with other competitors and see whether, are you still the lowest price, say maybe 2 or 3 months later, for instance. So as to ensure that your claim or the representation is accurate. I'll move on to discounts. Discounts are price benefits arising from a supplier's comparison to its usual price. So the difference between discounts and price comparisons, the section that's just before, is that here we are comparing prices. A supplier is comparing with his own previous price, right? So examples would be things like clearance sales. So initially you're selling at $10, for instance. Because of a clearance sale, you're selling at $5. So it's your own prices that you're comparing instead of with your competitors, as we've seen in the previous slide. But in terms of the principles, it's generally the same. You should use a genuine previous price to provide a basis for the price comparison. So sometimes I think it's we do hear of suppliers where they jack up the price, maybe just one day before, and then they say the next day, oh, it's a discount, when actually that price has always been the usual price that they are selling. So that is something that should not be done. And of course, suppliers should not mislead consumers on the savings that they can be achieved. So again, if you're making if you're saying that there's a certain discount that is made, and this discount would have to be a real discount, it would have to be genuine. And suppliers should not misrepresent on the duration of a sale. So if there's a representation that this will only be selling at 50% off for 3 days, for instance, then that 3 days would need to be kept to. It would need to be adhered to. You shouldn't misrepresent, and then subsequently, actually 1 week later, 1 month later, you're still having that same sale at that same price discount. And of course, suppliers should also not misrepresent the discount terms. By this, we mean things like maybe up to 50% off, or as low as. So these terms that you put before maybe certain prices, this would have to also, as suppliers, you should also ensure that these are not false or misleading, so that consumers, when they see that, they will know that, okay, it's as up to 50% off. So anything that they would expect something that is less, but not anything that is more. So yeah, if you look at the blue boxes, again, just to reiterate that we should use genuine prices. We should keep the records of past sales and prices, so that if there's any need there's any dispute, then you can just show that and say that, hey, but I've been selling at this price for a certain period of time. And to state the time span of discounts clearly and prominently. So if you have decided that certain discounts will only be available for a certain period of time, then you should state that period clearly and prominently, and of course it has to be accurate. And last but not least, the use of the term free. So suppliers of course do that, they give, some of you all may be quite familiar with providing free products or services, especially when you want to maybe entice consumers to try a new product so that hopefully eventually they will purchase it. So suppliers should ensure that if you make any of such representation, say, this particular good or this particular service is free, then it must not be false or misleading. If there are any terms and conditions, there are any, especially deferred charges, subsequently, this is free now, but 3 months later you have to pay. Then this would have to be stated very clearly and prominently together with the free representation. And you should ensure that the price of a good or service is not increased to cover the cost of the free item. So if you say that you need to buy this main item first before you get a free item, for instance, then this free item's cost cannot be added to the main item so that eventually actually you cover the free item's cost. The free item would have to be given out free or at $0 genuinely, right? So if there are any incident costs, say you will want to be charging shipping fees for the free gift, then that would have to be listed out clearly at the front for consumers to know as well. So one point we also want to note is that there's a need to inform consumers before the end of free trials. Usually when say it's a 3 months period, for instance, sometimes by the time it reaches that, consumers will have forgotten, for instance. So it's good to set reminders, to send maybe another email to remind consumers that, hey, the free trial period is ending. And if there's any cancellation process that consumers can engage in, then it's good to list that clearly and to provide clear and accurate, of course, information on the cancellation process. Right, so these are the 4 pricing practices in the guidelines. To very quickly sum up, the guiding principles that run throughout the whole set of guidelines is really that there's a need for suppliers to be truthful in your representations, in the claims that you make. Of course, the information that is provided, it has to be accurate, whether it's in terms of the prices that you set or even in terms of the terms and conditions that you list, that would have to be accurate. Information would need to be stated in a clear and prominent manner. Material information would have to be provided upfront. Don't just put it right at the end or in some obscure places where consumers would usually not see. And there is a need to ensure that you conduct research before any claims are made or you make any representation, so that you know for sure that this particular claims or representations that you make on your prices is accurate, or is as much as in terms of your due diligence that you've done that research. Right, so that is the last slide I have. I'll just leave you all with this quote, that there's a need to build, if you want to build your reputation as a trustworthy supplier, you want to do that by adopting transparent pricing and good trade practice.